YouTube. Hopefully my YouTube is working today. Sometimes it doesn't. There have been issues statewide on the YouTube. Okay, I think we're good to go. All right, let me get the record started. All right. All right, the court is calling cause number 2020 DCM 2377. This is a hearing on a motion for new trial filed by the custodial parent's attorney, Mr. Ricardo Rios. The custodial parent is Randy Salazar. Mr. Eric Maldonado is the respondent, being represented by Heather Hall. And the AG's office is being represented by Ms. Kaplan. This is, as indicated, this is a hearing on a motion for new trial filed on behalf of the custodial parent, Mr. Ricardo Rios. This time, let me have announcement of counsel, starting with the AG.
Lindsay Kaplan for the state, Your Honor, ready?
Okay, Mr. Rios, ready to proceed?
I am, Judge.
And Ms. Hall, ready to proceed?
Yes, Your Honor, thank you.
Okay, just for the record, the parties are present. However, they're in the waiting room. Since this is a motion for a new trial, I don't think I'll be entertaining any any live testimony at this time. However, if the need arises, I can bring them out of the waiting room. Rios, this is your motion, sir? Tell me what
Yes,
you want.
Judge. The current order, which was signed on the 12th of February, is my client is sole managing conservator, and Mr. Maldonado has standard possession. When this order was agreed to by the parties, Mr. Maldonado had told my client that he was moving back to El Paso. He lives in San Diego, California, and that he had a job here already. And so she dropped back child support and agreed to the standard possession order, thinking that he was coming. So after the agreement, then she learned that Mr. Maldonado is not coming back to El Paso anymore. He never intended to. The child is 2 years old, is about to be 3 years old on April 8th. Mr. Maldonado lived with my client and the child for 2 years. And then he left in May, at the beginning of May 2020. And since then, he has only seen the child 4 times. And the child doesn't really know him as daddy. And so what my client is wanting is she's happy that he wants to be in the child's life, but she wants just, some step ups before he takes her to California. This past spring break would have been 11 days, consecutive days, and 42 consecutive days in the summer. And the child's never been away from mom. So she just wants a step up plan, to integrate dad and the child before he takes her for long periods of time to California without her. And even though she's 3, for the past almost year, he's only seen her 4 times.
Anything else, Mr. Rios?
No, Judge.
Okay, well, I was looking at the order before, Ms. Hall, I'll wait for your response. But just to clarify a few things, Mr. Rios, I did look at the order and it appeared to be an agreed order that was entered. Parties were present in consultation with the Attorney General. They did work out all the issues concerning this order, including the standard possession order. And the standard possession order did provide for parties who live more than 100 miles from each other, which I believe in this case, that's where Mr. Maldonado is, somewhere in, where in California does he live?
San Diego.
San Diego.
Yes,
All right,
Judge.
so-
And I guess the key point is that he told her that he was moving back to El Paso. He even found a job. And that's what, we have some text messages, but, he told her that he was coming back to El Paso. He had a job, and so she wasn't worried about, or she didn't think about the child, being alone with dad for extended periods of time.
Okay. All right. Ms. Hall?
Yes,
Response?
Judge. What we would ask the court to consider is, I believe that the grounds for the motion for new trial is that there is new evidence that has come to light since the agreement. And I think one of the provisions is that you have to be unaware of that evidence. But the mother, the biological mother, has known since she met the father that he is from San Diego, and he was in San Diego and living there at the time that the agreement was made. Second, Judge, I would ask this court to also consider the consequences of allowing kind of a buyer's remorse type motion or granting that, because she's basically having buyer's remorse on her agreement that she signed voluntarily, knowing the evidence was, she had knowledge of the fact that he lived in San Antonio. I believe maybe the proper vehicle should have been a modification instead, if instead of this motion for new trial. I would also ask the court to consider that of the 36 months that the child has been alive, which will be, she'll be turning 3 April 8th or 9th. He lived with that child for 25 months. So he's only been away for 11 months, and then they proceeded to get an order a month ago. I would just ask for the agreement to stay intact because they both agreed to this. This was not an issue or order from the judge or the court or even from the AG's office. And I don't think it rises to the level of new evidence that was, or the petitioner was unaware of.
Ms. Kaplan, is there any position from the AG's office on this matter?
Your Honor, the state does not take a position as to visitation and defers to the court regarding this issue.
Right. Well, my question to the AG is, do you know who it was that did the negotiations between the parties back when this order was done? Do you have notes that indicate that? Was it an AG, was it an assistant attorney general, or one of the CS?
May I have a brief moment to look to see who negotiated the order?
Or was it an AG or was it one of the CSOs?
Your Honor, I know that I did sign off on the order, but I was not the individual that negotiated the order. If the court will allow me a moment to look back in my notes to see who did negotiate the order, and if possible, call that individual.
No, it's not necessary. I just want to know who, if there's any, if we can readily determine who, if it was an assistant attorney general or was one of the child support officers.
I do know it was not an assistant attorney general, that it was a staff member, but at this moment, I'm not sure exactly which staff member.
Okay. All right.
I could add one last thing.
Yes, sir. I was going to ask you for any last comment, Mr. Rios.
I think it would also be, well, my client wouldn't, if she wasn't misled, you know, they would have had to agree, or she wouldn't have agreed, and then let Your Honor decide on travel provisions as well. There's no travel provision in the decree. And so now that he's decided to stay in San Diego, I think that there should also be some travel provisions.
Okay, what do you mean by travel provisions?
Travel provisions for the child.
As far as the child, or
Is as far as the transfer of the child, and you know, the standard, if they buy airline tickets, you have to have the child there two hours before, and you know, an unaccompanied minor, they have to have an escort up until a certain age.
well, wouldn't those issues be determined if kind of inclined to agree with Ms. Hall that what we're really talking about here is not necessarily newly discovered evidence, but possibly a motion to modify visitation if the current visitation schedule is unworkable. And that's the term that's used in the family code, whether or not it's unworkable. So at that time, did the parties contemplate that Mr. Maldonado was going to remain in San Diego, in California? That could be possibly a motion to modify the visitation if the visitation is not workable. I don't know if has he even attempted to visit with a child since the order was done?
Yes, Judge, he actually was trying to exercise his visitation this past spring break. He drove in from San Diego, gave her notice. She failed to exchange the child. There were actually family members of hers were out in the street taunting him. So yes, he has tried to visit with the child according to the order that's in place.
Mr. Rios, do you have any information concerning that? Did he attempt to visit and he was denied?
He did attempt. He actually drove down here to show that he tried. I mean, he did try, and he did so. But he drove after knowing that that my client wasn't here in town. So
He wasn't in town?
That's correct.
He had texted her a bunch just saying, hey, I'm going to come down. I'll be here at this time to pick up Delaney. So.
Okay. All right. Mr. Rios, your motion, any last words, sir?
So I think it all comes down to the best interest of the child, Your Honor. And while he was with the child for 2 years, you know, she was a young age, she wasn't talking yet. And, you know, between 2 and 3, a lot happens. They start to talk, be able to express themselves. And you know, I think that time is a very crucial bonding time for the child and the parent. And you know, since May 5th, 2020, he's only seen the child 4 times. And so it all comes down to the best interest of the child.
So is she denying him the time to visit with a child? I mean, he drives in, you know, from California, and suddenly, all of a sudden, the child is nowhere to be seen and doesn't have time to visit with a child. If we're trying to establish a visitation pattern, I mean, it doesn't sound like she's doing her part to encourage that visitation and enable the child to have some sort of a bonding time with the non-custodial parent.
Well, the only thing, Judge, is that he was going to take this child who doesn't know him as dad for 11 consecutive days. You know, and she's very young, and you know, that would be very traumatic to be taken away from mom for 11 days Uh,
But she wouldn't even allow him to visit at that time. I mean, for maybe that day.
Oh, she's fine with him visiting here. And what, all she wants is, maybe spend a weekend or two here in El Paso to
Well,
get.
that's what I'm saying, Mr. Rios. When he showed up, why didn't she allow him to visit for a day, a weekend?
Oh, he didn't agree
Especially
to
since
that, Judge.
since he made the trip all the way from San Diego.
Yeah, he wouldn't agree to that. He said he rented a car. It had to be back the next day.
That's not true. Okay.
Okay, all right, well. I tend to agree with Ms. Hall that there really a basis for a new trial is not newly discovered evidence. I think the remedy in this time would be for your client, Mr. Rios, to file a motion to modify the visitation schedule and perhaps include in there what kind of visitation rights Mr. Baldonado would have as far as travel expenses, when exactly, I mean, I agree there might be some time to encourage the mom and child to at least establish some sort of relationship so that she's not, the child is not immediately just taken away, for a few days or whatever. I think
Right.
your remedy is the more likely remedy is a motion to modify the visitation.
Okay.
And is there something that y'all can, I mean, I can either, like, all I can do is encourage parties to try and work these things out. However, I don't think it's the proper mechanism is a motion for a new trial.
Judge, Mr. Rios and I have always been able to try to work things out. So we'll continue to work with the parties, right, Rick? And see if we can avoid further litigation.
Okay, well, that brings up a point that if I don't make a ruling today, in anticipation of some sort of a resolution on modifying the visitation schedules, I would encourage that. But at this point in time, the only matter before the court is a motion for new trial. For the time being, I'll go ahead and my ruling is the motion for new trial does not meet that criteria of newly discovered evidence. For that reason, I'm denying the motion for new trial. I encourage parties to try and work out visitation schedule, and if you all do that, I'll be more than happy to sign off on any agreement as far as visitation or motion modify what the modified visitation would be. Okay.
Thank you,
Okay.
Judge.
Thank you, Judge.
All right. Your clients are in the waiting room. You can talk to them separately or at some point later on down the line and try to work out this visitation schedule.
Yes, Your Honor. Thank you.
At this point, that's my ruling here today. Thank you all for your participation today. That concludes our hearing for today. Thank you all very much.
Thank you.
Thank you, Judge.
And I see Mr. Hargis is back. Mr. Hargis?
Oh, Your Honor,
Okay.
Mr. Nunez didn't show up for the hearing. So we get a reset?
You want to reset the case? Okay. Again, we're looking at July 6th. Is that the available date, JC? July 6th?
Yes, sir. July the 6th at 8 o'clock.
July 6th, 8 o'clock. Okay. We reset it at the AG's request for July 6th, 8 o'clock.
Mhm.
Okay, thank you.
We won't go back and let Ms. Castillo know that.
Okay, thank you.
She might be still in that waiting room.